memento to our esteemed speaker of the session. Globalization of the economy has opened the gates of cross-border transactions, leading to a plethora of complexities. In such cases, it becomes very essential to determine the relevant provisions and laws relating to tax incidents, and hence determination of residential status assumes prime importance. The place of effective management is the litmus test for determining the residential status of the company. This is the topic for our first technical session. I would now like to request CA Vikas Jain, Vice Chairman, Ahmedabad branch, to introduce our learned speaker for the session.
Past Chairman of the branch, Sri Yamal Bhai Vyas, learned faculty, Padamchand Khincha ji, Regional Council Member Parag Bhai, Priyam Bhai, Secretary of the branch Satyendra Bhai, Past Chairman Sanjay Bhai, Committee Member Harsh Bhai, Coordinator Hem Chhajir ji, members present over here, a very good morning to you all. Friends, today we are having with us very learned faculty Padamchand Khincha ji. I would not like to stand between you and the faculty because I believe that every penny saved is every penny earned. So one additional minute that would be given to the faculty would be benefiting the members a lot. So I would try and ensure that maximum time is available for the faculty. Just for the benefit of the members, I would be reading the introduction of our today's faculty, the profile. Padamchand Khincha ji is BCom LLB FCA. He holds 5th rank in BCom Bangalore University, 25th rank in CA final in November 1982. He is a partner in Messrs. H.C. Khincha and Company Chartered Accountants. Besides being in the professional activities, he is also there in teaching activities also. He is visiting faculty at IIM Bangalore. He was a faculty at the intensive coaching classes of ICAI, teaching income tax for CA final students, visiting faculty at the Direct Tax Training Institute of the Income Tax Department. He had many professional laurels under his belt. He has presented papers at various seminars, conferences all over the country, was writing a monthly column on Tax Patrika, a magazine in Hindi devoted to direct and indirect taxes, was a panel member of answering queries at NRI taxation on line of the Economic Times, was on the advisory board for answering queries of lexsite.com, a legal portal, was the convener of the study group formed to prepare the approach paper on the transfer pricing guidance note. Besides this, he has authored many books. He is the co-author of Tax Holiday under Section 10A and 10B analysis, author of the Tax Treatise of India, a compilation, authors of 3 booklets, Capital Gains of Non-Residents, Tax Deduction at Source, Concept of Indexation under Capital Gains, articles published in Current Tax Reporter, BCAJ, Journals of Institute, etc. With this brief introduction, I present before you today's faculty, Padamchand Khincha ji. Friend, one fact that is on the last page I missed, he has various sports achievements. Besides being a professional, he is also a sportsman. He was a keen cricket player, was selected to represent All India Colts versus the visiting West Indies team at Pune in 1978. He won prizes in the middle distance running in St. Joseph College athletic meets. Thank you, friends.
Dignitaries on the dais, ladies and gentlemen, it's a privilege to be here this morning to participate in a very important discussion, a forum for discussing the national wealth and how can we be conscious keepers of this national wealth. And I should also congratulate Nikita for laying the foundation for today's discussion with a very wonderful poem, an inspiring poem. Those thoughts were very fine, touched me deeply to say that yes, we need to be striving for excellence in a way that people do come and recognize us and respect us for that purpose. And I was looking at this aspect of the national wealth and the conscience keepers. Every country is desirous of ensuring that its national wealth is adequately protected. As a result of the nation, a country giving the freedom, the opportunity, the capability, the economic environment for the purpose of growing, studying, economically doing certain activities and ultimately acquiring wealth, that country can legitimately lay hands to say that from what the person earns, I will take some taxes. Because I have given him the freedom, I have given him the opportunity, I have given him the economic environment. And therefore, that person who is called as a resident of a particular country, the country would legitimately expect that all the incomes earned by that person concerned, a portion of the income shall go to the government concerned. The territorial nexus in relation to such persons is very easily established. But when a person who is not a resident of that particular country, to whom a similar amount of facilities have not been extended, a person who is therefore outside the country, to whom some other country has given him some protection, some opportunity, some assistance, some facility, he were to come into our country and were to involve in an economic activity, earning incomes therefrom, the question arises, what should be the basis on which we should be able to extract tax from him? One. Two, the second question arises as to on what portion of income should we tax him? On what portion of income? What is that income that is said to accrue or arise in this country? This becomes a matter that has been debated all over the world in terms of the territorial nexus, which is a precondition for any sovereign country having the right or the ability to levy a tax on a person or an entity. So this sovereign nexus has had its manifestations in various ways over a period of time. Different countries have evolved different types of parameters for saying when a person is going to be regarded as a resident, such that on the unlimited tax liability, that means the global income of that particular individual or the entity will be subjected to tax in a particular country. In relation to individuals, we have seen the aspect of physical presence. US is not necessarily physical presence, it could be the aspect of citizenship, or it could be the status of a green card holder. UK would say, I would like to look into your domicile status and levy a tax upon you. So even in relation to individuals, countries have evolved different mechanisms, different yardsticks for the purpose of determining whether the economic nexus with a particular individual is sufficient enough such that the rights of that country concerned can extend to levy a tax on the global income of the individual concerned. Over a period of time also, therefore, for corporates, countries have been evolving tests to say how can we tax a particular company concerned. What are the mechanisms by which, what are the tests that we can lay down for the purpose of ensuring that yes, this company is a resident of our country and therefore we should have a legitimate right of taxing the incomes of that particular company concerned. On the aspect of determining the residential status of a corporate organization also, we have had not a consistent yardstick. We have not had identical tests across the world. We have had differing tests laid down across the world for the purpose of determining where and by what basis, by what yardstick do you determine the residential status of a corporate organization. For example, India would say, if you are an Indian company, you are mandatorily a resident of India. On that there is no doubt whatsoever. If you are not an Indian company, then the tests have differed over a period of time. Till recently we had the aspect of control and management being wholly in India for a particular company which is incorporated outside to be regarded as a resident of this country. This aspect of control and management in the perception of the government has been given rise to a number of misuse. The Direct Tax Code had attempted to change the yardstick, but Direct Tax Code was never implemented. The Finance Act 2015 has now for the first time said, we will change our yardstick, we will change our measurement criteria for the purpose of finding out when a company is going to be regarded as a resident. Therefore, the Finance Bill had a particular proposal to say that if the place of effective management at any time was in India during that previous year, then the foreign company will be regarded as a resident of this country. So we, for a long period of time, had the aspect of control and management being situated wholly in India. This was the test laid down under the 1961 Act in relation to a company, the aspect of control and management. What was meant by control and management? Courts had held that control and management refers to the head and brain of an organization concerned. Therefore, refers to the seat where the board of directors were to meet, the place where the board of directors were to meet. And that is the place where the head and control is said to exist for a corporate organization. And if that corporate organization had its head and brain located, the word used was situated, wholly in India for the entire duration of 24 months, if the control and management, if the head and brain was in India for a period of 20 or all the 12 months, then that company, foreign company, though incorporated outside, would be regarded as a resident of this country concerned. The finance minister in the course of his budget speech made a statement that the aspect of control and management and the duration test to say that the control and management has to be situated throughout the previous year in this country has led to a good amount of misuse. Companies having a single board meeting outside India could have said, look here, the control and management of my company is not wholly in India, it is partly outside of India. The moment it is partly outside of India, these companies were able to escape the rigors of global taxation by demonstrating that, look here, some of my control and management is outside and therefore I am not to be regarded as a resident of this country. The FM said that this led to a creation of shell companies outside the country, as a result of which he said, I am going to change the yardstick and I am going to therefore make a proposal. The finance bill said that if the place of effective management was at any time in India, then the foreign company would have been regarded as a resident of this country. So from one extreme, we moved to the other extreme. The law earlier said if you had a board meeting outside the country, single board meeting, you would have escaped being regarded as a resident of this country. The proposal in the finance bill said if at any time during the previous year, the place of effective management was in this country, then you are going to be regarded as a resident. So if you were to be for a momentary sake also able to prove that the control and management or the place of effective management was in India for even a momentary time, then that company would have been regarded as a resident of this country. This led to a lot of exasperation from the community, the corporate angle, to say that no, this is going to be extremely difficult because India is now a multinational. A lot of its companies are going outside. There are a number of companies from India itself, both government and in the private sector, which have subsidiaries across the world. And if you were to regard these companies as residents of India because for some time, momentary at least, some key decisions were taken in India, it will amount to a huge amount of demerits for regarding those companies as residents of India and taxing the global income in this country. And this is also not in accordance with the international conventions and practices. The finance minister, therefore, when the bill became an act, he removed these words, at any time have now been removed. Therefore, the law that remains now is that a company, which is an Indian company, would be regarded as a resident of India, and any other company, if the control and management, that is the place of effective management is in India, will be regarded as a resident of India. The words at any time have been removed. The question for us therefore is, what is the significance of the removal of this phrase at any time? The law is not saying for any particular duration, for 6 months, 8 months, 12 months, the law is not saying anything. The only thing they are saying is, earlier it was a momentary point of time. If you are having an effective management in this country, you will be regarded as a resident of this country. We are now removing that aspect or reference to at any time during the previous year. And therefore the question arises for us as to what will be the criteria to be adopted by a particular company concerned to say that, look here, I am now having a place of effective management of sufficient duration in India to be regarded as a resident of India. Conversely, if I don't have a sufficient amount of control and management in this country or the place of effective management in this country, then I will not be regarded as a resident of this country concerned. This is the core or the crux of the issue for us to consider, debate and discuss. A small line, one single line in the Income Tax Act has the potential of causing a huge amount of disturbance in terms of the foreign companies being wary to say, should I step into this country? Should I make investment in this country? What will be the way in which the Indian government is going to look at the performance of the country, look at the management decisions being made, what is going to happen in relation to the actual decisions being taken or the actual work being executed, what is going to be important, or certain critical areas for us to all consider. We'll have about 45 minutes today, and therefore we will discuss this in three broad segments. The topic is going to be discussed in three broad segments. First is the law per se. What is the law? We'll also discuss the consequences of this law, second aspect. And the third would be, we as practitioners, what could be our recommendations to the companies concerned in terms of maintaining certain records, certain evidences. If at all you're planning for a situation that a company should escape from being regarded as a resident of this country, what could be the possible yardstick that we need to be suggesting to our companies concerned or the clients concerned, so that if at all they have a particular plan of action, how they could document that plan of action in a meaningful way, in a manner that would be able to satisfy the tax department that, look here, this company does not have the place of effective management in this country concerned. Therefore, we're going to discuss this in three broad segments concerned. One important point for us to remember is that for you to be regarded as a resident of this country, the place of effective management has to be in this country. For you to be regarded as not a resident of this country, you only have to demonstrate that the place of effective management is not in this country. You don't have to demonstrate that you are a resident of some other country. You don't have to demonstrate that. You only have to demonstrate negatively that the place of effective management of a particular company is not in this country concerned. Where is it? In which country is that poem situated is not the criteria at all. You only have to demonstrate only one facet of the issue concerned to say, look here, by virtue of the following facts that are available in the last 12 months period, the place of effective management of this company is not in this country. The fact that I didn't have a place of effective management elsewhere also is not the criteria. So only with reference to India, I will have to demonstrate that the place of effective management of this company is not in this country concerned. Two important facets, therefore, are in relation to the place of effective management are the location test and the duration test. The law would say that a company shall be regarded as a resident of this country if it is an Indian company. That's very known and understood for us. Alternative is if the place of effective management of that company is in India. The place of effective management, the word used is the place. Therefore, there has to be a location test. That the law itself is visualizing that there in a company you will have an effective management, and the place where the effective management is situated would be the place at which you are going to be determining, or on the basis of which you are going to determine the residential status of a corporate organization concerned. Therefore, the question is the place. Corporate organizations today are very dynamic in their operations, quite big. Quite number of people are involved in the business ventures itself. Therefore, the critical issue for us, therefore, that emerges is that could there be only one place of management for a company concern, or could there be multiple places of management? Because when you talk about the place of management, does it only presuppose only one place of management, or does it presuppose many places of management? If there are many places of management, then what do you do about it? So therefore, the important issue for us, when you look at the place of management, interestingly, it's not the place of management that is used in the statute, it is the place of effective management that is used in the statute. The place of effective management is used in the statute. Now, if you look into the OECD commentary over a period of time, the OECD commentary says there is a difference between the place of management and the place of effective management. Now, rather than going into the OECD commentary, how do you go about saying that what is the difference between a place of management and a place of effective management? I will go into, let us say, for example, the definition of a residence under the treaty concerned. Article 4 of the treaty will talk about under what circumstances a person could be regarded as a resident of a particular country. If you go to Article 4, it says a person or an entity could be regarded as a resident on the basis of physical presence, on the basis of nationality, on the basis of residence, or on the basis of a place of management. A place of management could be the criteria for a person to be regarded as a resident. This is in Article 4. Now, when you go into a tiebreaker test, let us say a company has a place of management in country A, it has a place of management also in country B. Therefore, by virtue of the place of management test under Article 4.1, this company would be regarded as a resident of country A, would also be regarded as a resident of country B. Then Article 4.3 would say, if a company is a resident of both these countries concerned, then you shall resolve this dispute by attributing residence to that country where the place of effective management is situated. Very interesting, therefore. Under Article 4.1 it says, the place of management shall be the criteria for you to determine residence of a particular country. If on that basis a company is a resident of two countries, then you shall resolve this dispute by the place of effective management. That country where the place of effective management is situated will be the country of residence, and the other country will be regarded as a country where the company is a non-resident. Therefore, Article 4.1 and 4.3 also uses two different phrases. Article 4.1 talks about place of management as a primary criteria for determining the residential status of a company. The place of effective management is in Article 4.3 to say, I shall resolve this dispute by looking at a little more narrower test, the place of not management, but the place of effective management. What do you mean by effective management, therefore? That management which has the decisive control over, which has the effective management means where in effect and in substance the management is residing. So, the treatise itself talks about place of management and place of effective management as being different. This is the evidence available to us under Article 4 itself. Go to Article 5. Go to Article 5, which defines the test of a permanent establishment. Under what circumstances a permanent establishment is said to exist. If you go into that, it says, Article 5, sub-article 2 would say, a permanent establishment shall invariably include the following: an office, a factory, a warehouse, a place of management. They say, a permanent establishment will invariably include a place of management. Even in Article 5, for the purpose of determining the place of the permanent establishment or the criteria of a permanent establishment, the treatise used the word, a place of management shall be a criteria for you to decide whether a company has a permanent establishment in another country concerned. So we have the place of management also in Article 5. So you therefore have three places now. Under Article 5, place of management, under Article 4.1, place of management, Article 4.3, place of effective management. Over a period of time, by deliberations, experts have come to a conclusion that the term place of management in Article 5 for the purpose of determining the permanent establishment is the most liberal. You can have that criteria in a most liberal manner for the purpose of finding out that you shall be regarded as having a permanent establishment in a particular country. It gets narrower under Article 4.1. So the place of management in Article 4.1 is narrower than Article 5.2. And the most narrowest and the most strictest definition, therefore, would be under Article 4.3 when you have the place of effective management being there. And therefore, effective management, therefore, would refer to the substance of the transaction, the substance of the whole company is concerned as to where the management is being exercised. How do you determine this? How do you determine this? How do you determine, what do you mean by this phraseology of place of effective management? Over a period of time, countries have been deliberating on this matter repeatedly. And they have over a period of time evolved different criteria themselves. If you go into the OECD Model Convention, there was initially discussion as to what would be the criteria for the place of effective management. In 2001, they had another study made to say that today digital commerce is becoming very important, and therefore we need to reevaluate. In a company that is exercising and having business digitally, where is the place of effective management? Because there could be many persons participating in a boardroom meeting electronically, and therefore how do you determine the place of effective management? So in 2001, a report was published about the impact of communication technologies on the place of effective management. They changed their criteria. In 2003, they again examined it and said, we'll change the criteria again. 2010, they examined again and they said, we'll change the criteria. In 2013, OECD had a commentary about it, and India was a participant too, and India gave it reservations also to say, your understanding of place of effective management, we are not agreeing to that. So when the OECD did recommend that the place of effective management shall be the place where the key managerial decisions shall be taken, India said, no, we are giving our observations on this, we are giving our reservations on this. We don't go only by the place where the key management decisions are taken. We also want the place of the location of the activities as a very important criteria for the purpose of determining the poem. So India gave reservations. Interestingly, when the direct tax code was being discussed, the direct tax code was referred to the Standing Committee on Finance, a parliamentary committee, to say, you need to go into this direct tax code and give recommendations to us as to the provisions, the way they have been drafted, in what manner they should be modified to suit the circumstances of the case. The Standing Committee of the Parliament, Finance of the Parliament, went into recommendations on the Direct Tax Code 2010 and made a specific observation to say that there was a reference to the executive directors and key personnel of the company. Their presence, their role was, by virtue of the original commentary, said to be very important, said to be determinative of the place of effective management. The Standing Committee on Finance said, no, you need to remove a reference to this executive directors and the key managerial personnel, indicating thereby that the recommendation of the Standing Committee of the Parliament was to go back to the Board of Directors only and no other criteria. So world over, not just in India, OECD, UN and India over a period of time have not been clear about what do you mean by the place of effective management. That's obvious because in a corporate entity, if you were to ask a person concerned, what is important in a corporate entity? Is it the decision making that is important or the implementation that is important? What is important for the success of an organization? We ultimately make a statement that national wealth has to be generated. Is wealth generated by decision making or is wealth generated by implementation or execution? What is that that is most critical in the creation of national wealth? If you say decision making is very critical because I took the right decision to go in for this product and therefore I've had the good success out of it, we have one criteria. If you say no, decision making is only half the story, execution is extremely important. Unless you execute those ideas concerned, how do you think a wealth will be created? We have another part of the story. The confusion world over is also on these two criteria only. Is it the decision making that is important or is it the execution that is very important? And therefore, we are not able to evolve decisively over a period of time as to what is going to be the most important criteria. Although historically, right from Section 6, Subsection 3 as originally formed, over a period of time, worth going through 18 ITR, 19 ITR, 23 ITR, 40 ITR, there are Supreme Court decisions and High Court decisions. They have already consistently held that what is important is the head and control, head and brain of the company concerned. The control and management invariably lies in the board of directors. So that place where the control lies, not even the shareholder, I may be 95% shareholder of a company concerned. I can't direct what the company has to take decisions. I can only, in the board, in the AGM has specific powers. Beyond that, I have no powers about directing the company concerned, controlling the company concerned. That control of the company invariably would vest in the board of directors, consistently over a period of time. This is what the Standing Committee on Finance ultimately recommended. Don't look at the post of the company, the executive directors. Don't look at key managerial person. Don't look at the two-tier board also, the management or the advisory council with the board of directors. To us, the most important criteria is the board of directors only. Therefore, they are the persons who shall yield the power to somebody else. They are the person to say, I shall give you the discretion to go and implement particular things. So on the basis of my discretion, you are going to have the authority. And therefore, I am the person who is controlling it. And if you are able to demonstrate this, then that's the place, that's the seat where you're going to say the place of effective management can be situated. Very interestingly, if you look into the Claus-Vogel's commentary, he said, you will have to decide this test on the basis of 3 I's. He says 3 I's are important. He says, does a person have the ability to interfere with a particular decision? Does he have the ability or the authority to interfere with the decision concerned? Somebody were to take a decision concerned, and somebody else is having the authority to interfere with that decision. Who is important now? The person taking the decision or the person who has the authority to interfere with the decision? Who is important therefore? I don't interfere, therefore I allow him to continue with the activity is one different issue. But do I have the ability to interfere with that decision concerned? Then the person who is having the ability to interfere is the person with whom the control lies. First test. Second test says, who is the person who is being informed of these actions? Who is being informed? Before I wait to take a decision concerned, I am required to report to somebody. I am required to inform somebody. If I am required to inform somebody, who is important therefore? The person executing or the person who is being informed? Therefore, the second test is saying is, the person who is being informed Therefore, the person to whom you are going to report to is the person who is going to be said to be the place or the person where the place of effective management is situated. And third is, who is the person who can influence a particular decision concern? Who is the person who can influence a particular decision? So if you were to apply this test in a particular situation concerned, there are alternatives A, B, C, and D. Now, whether the decision is between alternates A, B, and C, who will influence this decision concerned, that body or that individual who can influence this decision would be regarded or should be regarded as the place where the effective management is said to be situated. I thought this is a very wonderful way of describing things, to say that interference, information that is going to be given to him, and the person who can influence the decision-making concern. Those are the three tests that are to be consistently applied over a period of time by all of us to say, where does the place of effective management lie? But going back to the technicalities of what this section tells us today, it says the place of effective management has to be in India. I made a statement that the word at any time has been removed. So the question that a momentary presence of effective management hitherto would have troubled this company is concerned, the removal of this phrase, does it give some sort of a ability for a company concerned to say, I can have some presence of effective management in this country, but I still be regarded as a non-resident of this country. Though my presence is there, though my effective management is there in this country, I am acknowledging that. But I am making a statement that presence of effective management is of not substantial duration to regard that company concerned as a resident of this country. Is it possible for us to argue in this manner? No. We can't say that there are any case laws in section 6.3 because the law has been enacted just today. But under section 6 subsection 2, when you talk about a partnership firm and an AOP, we have the same test laid down today as is there in the case of corporates today. For a corporate entity today, effective management in this country can make it a resident. For a firm or an AOP, control and management at any time during the previous year can make that overseas firm a resident of this country. So if there is a foreign firm in US, part of the control and management is in India, then the foreign firm becomes a resident of this country concerned. So what is the test that is now being contemplated for companies was already the existing test for partnership firms, AOP and other entities under 6 subsection 2. In relation to this, we have had a Supreme Court decision in 1990. We also had a Madras High Court decision in 1890, both reading, where they have said that you can't just talk about a momentary presence of the management in this country. The presence has to be for a reasonably long period of time. Therefore, although in section 6.3 today, we don't have a duration test, going by the yardstick laid down by the Supreme Court in 1890 and also the Madras High Court in 1990, we can argue reasonably strongly that unless the presence is of substantial duration, small amount of temporary presence will not make the foreign company a resident of this country concerned. Therefore, the place of effective management has to be in India, is the criteria under 6.3. And they define that to say the place of effective management shall mean an exhaustive definition, shall mean that place. So duration is laid down, location is laid down, where key management and commercial decisions. The law is very interesting. It says key. Therefore, the most important, most significant out of the various decisions taken in a company concerned, grade them into A, B, and C. A will be the key criteria, the key decisions taken for the corporate entity. We'll identify where those decisions were taken, the place where those decisions were taken. Therefore, key management and commercial decisions. Very interesting. It's not just management or commercial decisions, it is management and commercial decisions. Management and commercial decisions. These terms are not very difficult for us to understand as to what do you mean by management decisions, what do you mean by commercial decisions. But they have to be key and they have to be on a cumulative basis considered. If I am only taking in charge of commercial aspects, somebody else is taking charge of managerial aspects, we are in two different jurisdictions, one could possibly and eminently argue that they are not in the same jurisdiction concerned. Therefore, in that same jurisdiction, there is an absence of key management and commercial decisions. Therefore, one could argue that because there is no cohesion or no convergence of management and commercial decisions, you can't say that there is a place of effective management in a particular or a single location concerned. Where key management and commercial decisions that are necessary for the business as a whole, that are necessary for the conduct of the business as a whole. So not just casual, that are very essential, very necessary for the conduct of the business as a whole, are in substance made. are in substance made. The law is therefore looking at substance over form, not just the real formality of doing things, but they should be effectively made there, and therefore the philosophy of substance over form will prevail in judging whether the place of effective management is in that particular state or not. This is the definition of place of effective management borrowed from OECD model commentary. Interestingly, therefore, the finance minister said that this concept of poem will be what is there internationally recognized, and therefore I am borrowing that. Logically, one could extend to argue that the concept as explained, expounded and understood internationally should also be relevant for the purpose of interpreting this term while we were to go and battle this out in the courts tomorrow when these battles were to emerge, as and when they will emerge. Having had a reference to the definition of poem, we also need to understand and look under the Income Tax Act as to do you find some resemblance of a similar expression elsewhere. If you go down to the Income Tax Act and find out, that will help us understand and analyze what is the understanding of these terms as used in section 6 subsection 3. Under 115 VC, we have a definition of poem as it is today in relation to tonnage tax. In relation to tonnage tax, we have a definition of place of effective management when I am a person who wants the presumptive taxation in relation to ships that are there loading cargo and passengers concerned. I can pay tax on a presumptive basis. Who is the person who is entitled to take advantage of that presumptive taxation, tonnage tax system, is there in the chapter. 115 VC thereunder defines what the place of effective management shall be. And interestingly, that definition of place of effective management is at variance with what is there in section 6, subsection 3. So having had an existing definition under the statute itself, the law has consciously said, for the purpose of 6, subsection 3, we will have a different definition. And interestingly, therefore, one may argue what will be the consequences for a shipping company in relation to two definitions. It will have to satisfy both the definitions concerned. It will have to satisfy the definition of 115 VC to be able to take advantage of the tonnage tax on a presumptive basis. And if it wants to escape taxation on a global basis under section 6.3, it will have to independently justify under the test of 6.3 that its place of effective management is not in this country, it has been situated elsewhere. It's extremely important for us therefore to understand that two definitions are there under the statute concerned, same term, defined differently. Obviously, therefore, they will have their relevance, they will have their importance in the respective context. For example, today, we have the definition of transfer under 2 subsection 47. We also have the definition of transfer under section 63. We had the definition of transfer under 269 UAF. So we had different definitions of transfers. And they were having their own roles or relevance in the particular context in which they were applied. You can't therefore say the definition of 2 subsection 47 shall prevail, because the law says unless the context otherwise requires there in 247. And courts have held that these definitions of the same term, that means defined differently at different places, will have to be understood in their context and therefore accordingly will have their relevance. So the difference in definitions under 115 VC will have its own relevance. You can't therefore import that definition for the purpose of finding out whether a corporate entity is a resident under section 6.3 or not. In 92 capital A, while defining the associated enterprise relationship, we have control or management. We don't have control and management. Under 2 subsection 14, which defines capital as today, the new definition also refers to control or management. Under section 5, we have only control. Where a business is controlled from India for a not ordinary resident, then that income in relation to a business controlled from India for a not ordinary resident shall also be accruing or arising in this country. We have no reference to management there. We have only reference to control there. So we'll have to therefore go into various connotations, various shades, various terms being differently used in different points of the Act, and ensure that each of these terms will have the relevance specifically for that particular context. We should not automatically import, understand in the context of section 6.3 that the same meaning shall attach. Although you may derive some benefit, you may use that for a persuasive value, but you can't necessarily import them automatically and invariably for the purpose of understanding the definition under section 6, subsection 3. And therefore, in relation to the effective management test may be key management and commercial decisions that are necessary for the business of the entity as a whole. Very interesting again, for the business of the entity as a whole, not for the segment of the business concerned. If there is a group entity having branches or having operations all across the world concerned, a particular decision relevant only for India will not be able to say that the place of effective management for the whole group is in India, unless this decision is taken forward all other places and implemented accordingly also. Then you can say that the decision taken in India is for the group as a whole, for the entity as a whole. And therefore, in relation to that commercial decision or management decision, the place of effective management is in this country concerned. You also have to therefore talk about, in relation to these aspects, certain treaties India has entered into. India-Belarus Treaty has a particular definition of poem. Very interestingly again, therefore, one could argue that India has entered into this treaty in Article 4 itself. The definition is given in Article 4 as to what shall be the place of effective management. One could argue that India being a signatory to this treaty, the definition thereunder should logically be extended to other treaties also. That's fine because the definition is largely coinciding now with the test laid down in section 6, subsection 3. Largely coinciding, therefore, one could possibly lay down that definition for the purpose of extending that definition to the other treaties also. But it's important for us, therefore, to understand that because of the new test being laid down, the place of effective management at any time during the previous year is concerned, it's possible that a company may be regarded as a resident of India. It may also by the same yardstick be regarded as a resident of some other country concerned. Then you will have a clash, dual residency clash will be there. Some countries like USA would say, if you are a resident of both the countries concerned, we will not give you the benefits of treaty itself. That could be a very difficult and a disastrous situation concerned. So when you're planning and advising clients concerned, you've got to be very careful about the treaty we're dealing with. US has its own consequences, Canada has its own consequences, Japan has its own consequences. Therefore, when you are a resident of two or more countries concerned, a corporate entity, you have to be very sure about the consequences that will emerge as a result of you being a resident of two or more countries concerned. This is the law in relation to the concept and the import of section 6, subsection 3. If for any reason you were to become a resident of India, this foreign company, incorporated outside, become the resident of India, what will be the consequences for us to understand? First thing is, I become a resident of this country. But what is my status? I am still a foreign company. Therefore, I become a foreign resident company. I don't become a domestic resident company. We have a definition of domestic company, we have a definition of foreign company. If at all, as a foreign company, I become a resident of India, I continue to retain my status as a foreign resident company. I am a foreign company, but a resident of India. As a result of which, therefore, although I am a resident, I will be liable to pay tax at 40% on my total income. I will not be getting the rate applicable to a domestic company at 30%. So resident will pay tax at 40%. That's an important consequence for us to understand. Now, the moment I am a resident, what will happen therefore is I am required to file my return of income. Now, this residency is a fluctuating concept. I may be a resident this year, I may not be a resident next year, I may be a resident thereafter. It's a fluctuating concept. Therefore, I may be required to file a return of income intermittently. That's the difficulty, or that's the interesting fallout of me being a resident in one country, 1 year, and not a resident in another year concerned. If you all, in the intervening years, when you are a non-resident, you had losses, you can't carry forward those losses because you never filed those returns itself. So a company that is intermittently a resident of a particular country concerned, especially India, and in those years when it was a non-resident, it had losses, it can't carry forward those losses because the precondition for carrying forward losses is you should be able to file a return of income. If you've not done that, you can't carry forward losses. So intermittently becoming a resident could have its own consequences of this nature. Next, what will be the way in which a person is going to recognize you in relation to 915, 916 or 917? Law would say, a non-resident paying to another non-resident royalties, interest or fees for technical services is not deemed to occur rise in this country unless the fellow who is receiving the services is utilizing it in this country or has been rendering the service in this country. Otherwise, a non-resident paying to a non-resident, by rule, the income is not taxable in this country, not deemed to occur rise. By exception, it becomes accruing in this country if you are fulfilling certain tests laid down in either 916C or 917C. When a non-resident pays to another non-resident. Reversal will happen when a resident is paying to a non-resident. Invariably, the income is deemed to occur or rise in this country. You shall escape only when you fall within the exemptions of in relation to a business carried on outside of India or in relation to making or earning of income from a source outside of India. You can only escape under those limited categories. By exception, interest, royalties and FTS paid by a resident shall be deemed to occur or rise in this country. When I now make a foreign company a resident of this country under 6.3, I will move from 917C to 916C. From 917C to 917B, or from 916C to 916B. That means that non-resident paying to another non-resident interest, royalties, or fee for technical services, all these payments will be by default regarded as accruing or arising in this country. There will be significant consequences because I wouldn't have done the TDS, I wouldn't have done therefore there will be disallowance of the 40 even, serious consequences will arise. Very interestingly also, when you are making a payment to a particular company concerned, how do you determine whether that company is a resident? Today, on 8th of August, you are making a payment to a particular company concerned. How should you apply? 195 or 194J? Let us say you are making a payment to one of the group associates of Microsoft somewhere in Ireland. How do you now say that this Microsoft Ireland is going to be a resident of this country or a non-resident of this country? Because depending on the residential status only, you're going to say which section applies. If it is a resident, 194J will apply, or 194I will apply. If it's non-resident, 195 will apply. For persons making a payment also, it's going to be extremely difficult because they don't know what is the resident status of a person concerned. When you are making a payment to me, when you're making a payment to me as an individual, if I were to take a job tomorrow and I go out, I become a non-resident automatically. I become a non-resident, and therefore your characterization of payments to me would be incorrect because by a particular event subsequently, I've changed my residential status. This is something that has been facing companies all across, nothing new about it, but it's a very live situation for companies which are able to escape very easily from the clutches of 6.3 earlier are now getting easier caught into 6.3 and saying that, oh, in relation to TDS aspect, therefore, compliance could be an extremely important aspect. You'll also have the flip-flop between, if you are a non-resident, it will be transfer pricing. If you are a resident, it will be domestic transfer pricing. Which law is to be complied with? We'll have an issue about that also. Resident to resident, domestic transfer pricing, different yardstick, different transactions are being covered. Non-resident, transfer pricing under Chapter 10 will be a different yardstick whatsoever. You don't know, therefore, you have to be very sure which is the law you're going to apply in relation to compliance. Although, by the year end, you'll be able to at least determine reasonably whether you're a resident or a non-resident and accordingly apply the appropriate law. You'll also have this 163 implication, agent of a non-resident. The foreign company remains agent, fine, you are in trouble if you are the person from or through whom the non-resident is in receipt of income. But if you are a resident, then you can't have the aspect of 163 coming in. But more importantly, if I become a resident of this country concerned, under 149, the law tells you that income accruing outside for the last 16 years, I can catch you. For the last 16 years, the question therefore arises, can they tax you for the last 16 years? Interesting propositions are emerging now. Can they tax you for the last 16 years? Resident, non-disclosed income overseas, can they tax you now? The question is very fine theoretically, but the answer is very easy because for the preceding years, if I was a non-resident, income accruing or rising to me outside but not taxable in this country, and therefore the question of income escaping assessment should not arise at all. So although potentially may be exposed to 16-year taxation, in reality, if you're able to demonstrate that for the earlier years I was a non-resident concerned, then there will be no situation of those overseas income being taxed in the hands of a person concerned. You also have the MAT implications coming in to say that are you liable to pay MAT under a particular situation? We have had the APSHA committee giving its report now to say that FIIs were liable to pay MAT tax at all, and they made a categorical observation that the terms of reference to us did not want us to examine the implications of a foreign company being liable to MAT. Therefore, where a company becomes a resident, it will have a tax liability, it will have a MAT exposure also. That's an important aspect. How do you prepare account for this company concerned is another important aspect for us to look into. These are some of the implications. By the time approaching, I will therefore spend some time in relation to what are the precautions, what are the procedures, what are the steps we need to be very careful about. In the course of this speech concerned, the FM made a statement that we are going to give guidelines for the purpose of helping the tax administrators as also taxpayers as to how to determine the residential status. They are yet to come out, although when we met the top officials about 1.5–2 months ago, they said they are in the advanced stage of being drafted now, yet we are not yet seen these guidelines. Interestingly also, the law does not postulate these guidelines as a part of the statute. This is therefore coming by virtue of the powers of the board under 119. Therefore, the binding effect of these circulars itself is suspect because you can challenge these circulars to say they are not there in the statute, they are not getting the powers from the statute. Therefore, I will not implement those, I will not accept those to the extent they are not beneficial to me. That is a proposition we'll have to keep in mind. Although the board is going to give guidelines, it's important for us to understand, therefore, that why the board should give us guidelines and what the board is going to do. If you were to understand, quite a lot of government companies have subsidiaries overseas. Big companies, Oil India, Coal India, are having subsidiaries all across the world. And do you think any of the subsidiaries have the wherewithal to take a decision overseas? Who takes the decision for this government companies concerned? Who takes the decisions now? All these companies, the decisions are taken at Delhi only. All these decisions. Nobody has the ability to wag their tail also. That means if the test of effective management is very literally applied, all these companies that are subsidiaries of government organizations would become residents of India and they will be liable to pay tax in India on their global incomes. Government therefore has to find a way out to prevent its own companies from being regarded as residents. It has to. And in the process, therefore, when it's going to give you some sort of a leeway to protect this government companies concerned, obviously, those leeways, those concessions can't be confined only to government companies. They should be available to everybody else also. And therefore, we should expect and await these guidelines concerned to say what does the board say in relation to the determination and the tests that are relevant for the purpose of finding out where the place of effective management of a particular company is. The onus is largely upon the person who is making a statement. Therefore, if I were to make a statement that I am a non-resident of this country because the effective management is outside, primarily the onus is upon me. If the department were to say, no, no, you are a resident, and that statement is by the department, then the department is required to prove by the following circumstances, you are the owner, you are the a resident of this country because the place of effective management of that company is located in India concerned. So the most important aspect for us to look at is two tiers. To me, this is an important aspect for us now. That consistently courts have held. We made a statement that the control and management were to reside in the board of directors. That's the consistent position. I don't think that could change even now. What is going to change even possibly now is I'm going to go one step lower, down to a committee that is there below the board of directors. I'm going to go down to the management committee or the advisory committee or the senior vice president's committee, which don't participate in the board, but who are given significant powers, who are technologically very well qualified, and therefore they're able to drive the business concern. To me, therefore, it's extremely important that we may possibly go one layer down below the board of directors level to say, are there any key personnel who are actually not a part of the board, but who have significant powers? That is the identification that we all will have to do now. And out of this, therefore, the focus would be on two committees, therefore, the board of directors and this managerial committee or the supervisory committee or the executive committee or advisory committee, whatever you may call it as. Is possibly going and percolating down to one level below. And we'll have to therefore examine the cumulative effect of the decisions taken by the board of directors as also the second tier level committee. And a cumulative analysis of these two levels will help us to understand where the place of effective management of this corporate entity rests. That's the most important aspect. To me, what's happening, therefore, possible is that there is a dilution, small amount of dilution, not significant dilution, a small amount of dilution. By limiting ourselves to board of directors, we are examining a narrow compass only, possibly go one level below and find out which other committee is involved in key strategic decisions of the organization concerned and examine that. Once you examine that, then you have to find out where these committees are meeting. Extremely important. Where the directors are meeting, where the executive committee is meeting. You may talk about the teleconferencing, all that is fine. What's important for us, therefore, to find out if a person is outside, not participating from the place where the agenda is, where the place stated to be of the meeting is, where the minutes are recorded, where the secretary is present, where the chairman is present, and somebody else is participating from some other place concerned. It's extremely important for us to build as an evidence concern that the notice should state where the meeting shall be held. The secretary should be there, the agenda should be recorded there, the minutes have to be recorded there. And you will have to therefore say, somebody who is outside shall participate in that meeting at that place by video conference or teleconferencing. So you will have to create an evidence to say that the key as the place of management or the place of decision was so and so jurisdiction and somebody else participated from other jurisdictions concerned. That's an extremely important aspect for us in relation to electronic participation in to board meetings concerned. from a practical point of view, two other important aspects are obtain a tax residency certificate for an overseas jurisdiction. That will be a statement by the other country concerned to say, look here, this company is a resident of my country concerned, and therefore, largely, the place of effective management is going to be there. And OECD is very categorically saying that the place of effective management can be in only one jurisdiction, although the place of management can be in multiple jurisdictions. OECD has repeatedly stressed this over a period of time to say, you can have multiple places of management, but you can have only one place of effective management, and therefore the TRC being obtained by another country or from another country would help us significantly in telling the government concerned, look here, I am a resident of that country concerned. Another important point for us to look at and understand and implement is that your pricing policies between these two affiliates has to be at arm's length. At arm's length. The moment you are at arm's length, you can demonstrate financial independence. The moment you are having an independence, you can say, my control is not there, my control is somewhere else also. The moment you are able to demonstrate, therefore, that your relationship with your affiliates are arm's length, then you don't normally and naturally extend your management into another jurisdiction at all. If an Indian company is a subsidiary of a US company concerned, it's able to demonstrate that the relationship between the US company and the Indian company are arm's length. That means the US company is not having a control, is not having the management here because it's able to demonstrate that the Indian company is functioning adequately, being compensated properly. Means that the US company is not exercising dominion, not exercising control, not having management here. You can, by virtue of this analysis, prevent the US company from being regarded as a resident of this country concerned. And during the course of the year, list down key decisions of the organization. List down all decisions for the time being, whether they are minor and major in your perception. List down all the decisions concerned. Make a statement who made those decisions. And at the end of the year, evaluate these decisions concerned. Make them into A, B, C analysis to say which are the most critical decisions for an organization, which are less critical decisions for an organization. And after an analysis, because the board is very clear, the FM is very clear that POEM is a fact-based exercise. It's not a law-based exercise, very categorical to say that it is a fact-based exercise, and therefore what facts ultimately actually unfold are going to be the key for the purpose of finding out and determining whether a company is a resident of a particular jurisdiction or not. And therefore, it's important for us to list out those decisions concerned, find out who are the persons who are involved in that decision making, find out where the decisions were taken, grade those decisions concerned, and maintain adequate evidence to demonstrate that these decisions were taken at particular places. I made a statement about agenda, about notices, about minutes, about therefore decisions being taken. Create and record those adequately, properly to demonstrate that these were decisions taken by so and so persons concerned at a particular jurisdiction or at a particular place concerned. You also have therefore to say that in relation to a company concerned, the presence of an independent director could also be important. That means that will indicate and demonstrate that this person is an independent director who participated actively, indicating therefore the board is able to decide itself, not being influenced by somebody else, and therefore possible for us to demonstrate that there will be a little limited influence of another overseas company in relation to the functioning of the Indian company concerned. If you like to therefore evolve over a period of time certain of these tests concerned, we'll be able to by fact demonstrate that a particular company is having the place of effective management at a particular jurisdiction itself. If our facts are strong, believe me, it's going to be that much easier for us to win the battle, because it will be for the department then to go and prove that the facts that have been disclosed are not the entire facts. There are some other better facts which are not properly revealed by the company concerned. That will be on the department concerned to lead those facts, which is going to be extremely difficult. And therefore, if you are able to tabulate these decisions of an organization concerned, grade them well, tabulate them well, and find out where the decisions were taken, by whom these decisions were taken, and come to an appropriate conclusion, we will be able to make this poem not a fiction, but a reality. Thank you all very much.
Thank you, sir. We are truly enriched by your knowledge and expertise on the subject. With this, I now request CA Hemcharger to propose a hearty vote of thanks to our esteemed speaker.
Our first topic, poem, was never really a poem. It ended up being a riddle. Respected our eminent speaker, Mr. Kincha sir, our past chairman and member of Gujarat State Finance Commission, Yamal Vyas, Vice Chairman of Ahmedabad Branch, Vikas Jain, Central Council member, our next speaker, Mr. Dinal Shah, and Regional Council member, Priyam Bhai and Parag sir, Secretary Satyendra Raja, and dignitaries of the dais. It is pleasure and honor to present vote of thanks on behalf of Ahmedabad branch of WIRC to our speaker, Padamchand Kincha sir. It is sheer my privilege to be standing here. Sir, it is our privilege to have you here. We thank you for giving us the clarity on the topic and deliberations on the issues for determining the residential status. Thank you so much, sir. I request everyone to please give a big round of applause. Thank you. We'll be having tea break for 5 minutes and we'll assemble here in 5 minutes. Thank you so much.
निकाल दो सब प्लग कल से तो बहुत अच्छा है ચાલુ છે ગૌતમભાઈ નું તો પિયુષભાઈ ગૌતમભાઈ નું રેડી છે